Justice Goliath, I'm going to commence by reminding myself and reminding ourselves that we are engaged with an interim interdict. There's been a lot of debate at various stages regarding the merits of the review, but we all know that the merits of the review play a defined role, and in some cases limited role, in the determination of interim relief for good reason, because obviously the merits of the review will only become more fully apparent as the review record is made available, the supplementary papers are furnished, and the matter is fully developed. So that is the warning that one has to bear in mind, and it's in that context that one perhaps will turn back to the outer decision. That is in the bundle of authorities that the city handed up to you, and you'll be well aware of the background to that decision. It was an appeal against an interim interdict that's against the implementation of certain decisions that had been made, including environmental decisions in relation to the proposed e-tolling road system in Gauteng. And perhaps one can go back to paragraph 41 of outer, and that is at page 259 of the authorities bundle that the city has handed up to your ladyship. And in paragraph 41, the court per Moseneke, Deputy Chief Justice, talked to the test for interim relief and said as follows: the High Court relied on the well-known requirements for the grant of an interim interdict set out in Setlegelo and refined 34 years later in Webster. The test requires that the applicant claims an interim interdict must establish a prima facie right, even if it's open to some doubt, a reasonable apprehension of irreparable and imminent harm to the right, and one must just emphasize that. If an interdict is not granted, the balance of convenience must favor the grant of the interdict, and the applicant must have no other remedy. And in paragraph 42, Justice Moseneke affirmed the test despite some reservations on the part of the government applicants regarding the suitability of that test. And he then went on in paragraph 48 to look at the elements of the test, 48 and following. And he said as follows: in relation to the prima facie right, he said, at the outset, the High Court had to decide whether the applicants had established a prima facie right, although open to some doubt. It examined the grounds of review and was persuaded that they bore prospects of success, and that therefore the applicants had established a prima facie right to have the decisions reviewed and set aside. Two comments are warranted. First, we heard full argument on the merits and the grounds of review. He said, first, we heard full argument on the merits of the grounds of review. Perhaps just as you heard yesterday, where if one assessed the time in the argument devoted to the grounds of the review, as opposed to the argument dealing with the interim interdict requirements, they bore no relationship, to the extent that even some of the interim interdict requirements were even dealt with in the oral argument. But in any event, he says, we heard full arguments on the merits on the grounds of review. I'm unable to say without more they bear any prospects of success. That decision I leave to the review court. So he's effectively saying in this particular case, it wasn't even appropriate to pronounce on prospects of success, and we'll get to the reason why. And second, the court said there's a conceptual difficulty with the High Court's holding that the applicants have shown a prima facie right to have the decision reviewed and set aside as formulated in prayers 1 and 2. The right to approach a court to review and set aside a decision in the past, and even more so now, resides in everyone. The Constitution makes it plain that everyone has the right to administrative action that is lawful, reasonable, and procedural fair, and in turn, PAJA regulates the review of administrative action. Under the Settler-Geller test, and I must emphasize this because it's inclined to be overlooked, under the Settler-Geller test, the prima facie right a claimant must establish is not merely the right to approach a court in order to review an administrative decision. It is a right which, if not protected by an interdict, irreparable harm would ensue. An interdict is meant to prevent future conduct and not decisions already made. Quite apart from the right to review and set aside impugned decisions, the applicant should have demonstrated a prima facie right that is threatened by an imminent or impending irreparable harm. The right to review the impugned decision did not require any preservation pendente lite. Now, against that backdrop, if one turns to the case that has been made out in the papers, if you were to turn to page 101 of the founding affidavit, paragraphs 202 to 204, it's my respectful submission that the requirements for an interim interdict have been established. 203, the facts set out above establish a strong prima facie right warranting protection by this court, namely a right to review of the unlawful decisions at issue, which themselves compromise the rights of the applicant to lawful action. Paragraph 204, it's furthermore beyond doubt that the anticipated harm, now this again is to be considered in the context of the remarks of the Constitutional Court in Arta. It's not appropriate just to talk, as it were, of harm generally without tethering the harm to the right. It's the right which you seek to protect in the interim interdict stage, which, if not protected, that right will be irremediably damaged. So it's...
Rosenberg, can I just interject at this stage? The right to preservation of tangible and the right to preservation of a tangible or intangible heritage resource, yes. Would that not be a right that the court should consider today?
Well, when your ladyship asked counsel for the applicant yesterday, what in fact do the applicants seek? The first response was the applicants seek a lawful and procedurally correct decision in the review. And the purpose of that decision, getting that decision, may be to allow them in due course in the review to present their claims, to have intangible heritage consideration properly considered in the course of the decision.
Does the first respondent dispute that the river would be significant in respect of both tangible and intangible heritage? Because as I indicated yesterday, my impression is that there's no dispute of fact with regard to that aspect.
I think your ladyship is quite correct that the heritage impact assessments undertaken on behalf of the developer, make it clear that the river, the Liesbeek River generally, running through the wider area from the slopes of the eastern slopes of Table Mountain right through the southern suburbs, right through the inner city, that river as a whole is significant, particularly when taken into or placed in its historical context, and we'll go there. And it was, in fact, for that very reason that the heritage impact assessment made it central to the memorialization steps that were to be taken as part of the development. So your ladyship is quite right. The river is central to as it were, the history, central to the cultural landscape.
Would the applicants then not have established that first requirement of a prima facie right?
No,
when one considers the historic cultural significance of the site?
Yes, but one must remind oneself, and I think it became clear in the discussion, yes, it's a right that in fact will potentially be irreparably damaged if in fact it's not protected at the moment. Now, the basic right in question in this matter is, as counsel put it, the right to in fact have a proper lawful adjudication of the development application. An adjudication where whatever claims or significance are attached to, for example, cultural assets such as the river are properly taken into consideration in the decision. At the outset, one makes two propositions in that regard. That right is not threatened. The right to have the significance and the meaning and importance to the applicants of the river, just to take one example of the cultural heritage or landscape, properly considered in the decision or in the impugned decisions. We say, of course, that decision, the decisions have properly taken that into consideration, but if in due course the review court were to find that that's not the case, the decisions, as the applicants have indicated is their intention, will be reconsidered, and if, for example, insufficient weight or any other direction in relation to the river or any other aspect of intangible cultural heritage is demonstrated to occur, that will be set to right. The question is, in relation to the river, for example, or any aspect of the intangible cultural heritage, does that require interim protection now, failing which the right that the applicants have to a lawful environmental decision taking into account a proper heritage impact assessment and all relevant considerations, will that right be irremediably damaged? We say clearly not. And there's no suggestion that if in due course it is demonstrated that the environmental authorizations were irregularly granted, that they won't, on review, be set aside. It's not been suggested that there's any reason why that shouldn't happen. The decision be considered afresh, and particularly in the context of this matter, and I'll come to that, where one is dealing with intangible cultural heritage and one is dealing with a situation where no actual tangible heritage resources have been destroyed and which can never be recovered, where one is dealing with a situation like this, where all that will have happened in the interim is an entirely transformed site with little or no tangible connection at the moment has been further transformed or changed from its currently transformed state or partially transformed, is there any reason whatsoever when the review decision maker has to exercise its jurisdiction, proper protections, if those are appropriate, or further protections or different protections can't be put into place? And we say that there's been no suggestion anywhere in the papers that that can't happen. If, for example, we know, and I'll seek to demonstrate to your ladyship, that as far as intangible cultural heritage is concerned, we've made the point in our heads of argument that particularly in the environment of today, in a layered urban landscape and environment, freezing a cultural landscape on the basis that no further development should take place, it shouldn't be altered at all, is only considered appropriate in the most unique of situations. A fortiori, where we're dealing with a landscape that is as transformed as the River Club landscape is in the heart of the urban conurbation, there is no landscape to be preserved or frozen. What essentially the appropriate protections are, and these are recognized protections in the literature which we've referred to, where appropriate steps are put in place to protect intangible cultural heritage. The appropriate protection measures are preeminently steps taken to record and memorialize the culture in question, the intangible culture in question, ceremonies, rituals. As your ladyship pointed out yesterday, in that regard, the intangible cultural heritage expert can only, as it were, document and record that with or through interaction with the community concerned, because the community is the repository of that knowledge. So it's a question of recording, memorializing, and in that way creating protection for the cultural tradition, the rituals, all the intangible elements of that. And secondly, equally, in this case, a protection also can be found in the context of rights of access, very important, because we have a site where for probably many, many years, and certainly since more than 100 years, this has been a site where there has been limited, if any, public access, or certainly no access entitlement of any kind. Not only is it a site where there's been very confined forms of regulated access, as I say, it's a site where there is not one scintilla of memorialization or commemoration of any elements of the cultural heritage in question.
Who would be to blame for that?
Well, I suppose that one has got to say that there could be...
Most certainly not the indigenous
Yes.
people, not the First Nations. They cannot be blamed for that.
Of course.
Because they are a vulnerable group, marginalized, vulnerable group. So the fact that there's nothing there for us to see today, wouldn't that just be a neutral factor? Because based on what the amici said yesterday, they were what's the word that was used? But anyhow, they were deprived of their land. They were chased off their land.
Yes.
So the fact that there's nothing there at the moment, would that not just be a neutral factor in this case?
If I could answer the first question, who's to blame? That may be a debate, and there may be varying answers to that. There may be contributors to that. With respect, I don't think that helps us with the problem. Getting onto your second question, where you say, well, you have a transformed site where, in fact, there are no signifiers of the intangible cultural heritage, other than perhaps,
Sorry, you must say
for example, the river.
No signifiers of tangible.
Yes.
Well, the tangible resource is the river itself.
Yes, but it's also part of the historical landscape, which has a particular significance for the community. Whether it's, and perhaps this has never been made clear, because there have been repeated requests to indicate details or to contextualize, and, for example, to provide information whether there are specific rituals, ceremonies that have been traditionally associated with the river, with the confluence, which we know isn't on the site itself. But be that as it may, the fact of the matter is, one, to repeat the point I made earlier, one has an entirely transformed site, which in its present state of limited access and relative degradation, particularly in relation to the important elements surrounding the site, the river, is a site which, in the circumstances, if in fact a process of recognizing its association with indigenous culture, indigenous tangible, intangible cultural heritage, the recognized protections are the kind of protections which emerged in the course of the consultation between the authorities, the developer, and the First Nation groupings. But to then go back to the point that I made, in the context of this matter, we have, as I've indicated, the present prevailing situation, which, subject to the construction that is underway, represents the partial transformation of an already degraded and transformed site. We have on the west, as your ladyship will recall, an excavated and unlined channel. It's been referred to as a ditch, effectively, of the Liesbeek River, as Dr. Townsend pointed out in his first heritage impact assessment. Of course, the river, he describes, it would have meandered and changed course from time to time. And we know that re-excavated ditch on the western side of the channel of the property had previously, at a stage, been infilled. It was sometime between 1960 and 1980 that it was reclaimed and infilled. Before, in 1990, it was dredged to allow for polluted water, effectively, to backflow from the Black River into what is described as a deep ditch. And, of course, to manage part of the city's stormwater. And it's, we know, polluted. It has little or no ecological functioning at present. And on the eastern side of the property, we have the canal. The canal represents the flowing river in its present form. Its meanderings now find themselves at this part canalized, but this is where the river runs. And as Dr. Townsend points out, it's the water and the running water which is particularly significant. The river might change course, but where the river runs is of particular significance because that's where the river water is located. That's where the crossings are made or would have been made across the river. That's where the ceremonies, the rituals may be performed. So on the western side, equally, we have a polluted, unfortunately at this stage, litter-strewn canal. Now, and as far as experiencing any kind of floodplain is concerned, the historic experience of the floodplain and the river crossing, well, of course, that is an element which is entirely absent from this largely infilled site. Now, it's in that backdrop, against that backdrop, that we, as your ladyship have pointed out, we see what has been proposed, the protections that have been proposed. Those protections involve, amongst other things, the restoration of ecological functioning to the old river course on the western side in the form of creating water swales, water ponds, indigenous vegetation, and as it were, establishing that as a functional part of the ecological system on the site. We know on the western side there is the proposal to create an unlined river course. On the eastern side, to create an unlined river course with a 40-meter corridor or band. The intention with that is to recreate in forms of the design and symbolism the old river crossing elements that are of importance in the vicinity of the river. Equally, there is an intention to create from east to west a band some 70 meters wide running right across the center of the property that in turn will be crossed with a bridge. You'll recall that one of the changes in the design had been to break the construction up into precincts on the northern side and towards the southern side and create this broad band in the center, which also is intended in its way to recreate the elements and the feeling of the old floodplain river crossing components. And your ladyship will be aware that some 60% of the site is going to be in one form or another accessible to the public. Accessible both via that proportion which is going to be registered as public or zoned as public open space, and in addition, accessible via the creation of servitutal rights. So a substantial proportion of this property is going to be accessible, and it's going to be accessible not only for particularly confined purposes, it's going to be accessible in the context that it is going to contain and provide an amphitheatre, a memorial and eco-centre, eco-trails, walking trails, general recreational purposes, and that's in the context of an emphasis in creating an amenity to, in fact, celebrate the culture, the intangible culture in issue. So we would emphasize that in this context, what is proposed is immeasurably better than what has ever been there before in recent memory. We would emphasize that in the context, as I said, of current best practice regarding protection of intangible cultural heritage rights, this is the way to go. The suggestion that, in fact, what might be contemplated is the restoration in this urban environment of the entire site, approximately 15 hectares, to its pre-colonial status. And it was suggested, it was seriously suggested that that was a feasible option. Not only just freezing it, not freezing it, but as it were, on the entire site trying to recreate that part of Cape Town as it was in the 16th century, seems to me the kind of protection that would be effectively entirely, certainly not one that one could conceive as ever having been recognized, entirely unprecedented, to try and turn back the clock 4 centuries.